Dear students, I am Professor Vibhuti Patel, Head of the Department of Economics of SNDT Women's University, Mumbai. Today's topic is sexual harassment at workplace, that is in paper number 4, Women in Economics, and module 17. Sexual harassment at workplace has been declared as one of the greatest occupational hazard of the 21st century in the world, and World Bank has also acknowledged it, because this has created, because what we see is that throughout the world women are entering all walks of life in the economy. Earlier, which was supposed to be the male bastion, they have now been quote unquote invaded by women, and the new kind of ecosystem which is totally male oriented finds it very difficult to cope up with this new entrance in the field of work. So, in the world of work, we see a new kind of power equations emerging because of this entry of millions of women in all sectors of the economy. The macroeconomic scenario has also changed because of the informalization of economy. Most of the jobs, they are temporary in nature. There is a massive contract labor, casualization of work has taken place. There is a informal arrangements are there at the workplaces, and labor standards have eroded in a massive way in this whole race of economic globalization. There is disintegration of workers' association, the trade union movement has also disintegrated, and there is a loss of collective bargaining. So, each worker, a woman or a man, they are atomized and they have to negotiate for their safety more like an isolated way. And this has led to sexual harassment at workplace. Women become more vulnerable when they don't have a united force, because women united, they never get defeated. That has been the motto of women's movement, but that kind of situation has changed. Now, what is sexual harassment? It is defined by Supreme Court guideline. It was defined in 1997, which was called Vishakha guideline, and that defines sexual harassment as any physical contact, demand for, request for sexual favors, or sexually colored remarks, or showing pornography, or any other unwelcome physical, verbal or non-verbal conduct of sexual nature. For example, leering, dirty jokes, sexual remarks, showing them sexually charged any visual, and also making a very aggressive physical contact. A legislation, now we have a new legislation, Prevention of Sexual Harassment at Workplace in 2013 to end sexual harassment of women at workplace, and it was passed by Parliament of India, and we also have a rules for its implementation, and there have been now very detailed guidelines have been given for the employers. Let us get into the history of fight by Indian women against sexual harassment at workplace. Since late 80s, early 90s, several incidences, it was women in the public sector who were the first one to report cases of sexual harassment, and taking it to its logical conclusion, and so many people were punished, whether they were in the big corporate houses or whether they were in the government offices or they were in the public sector enterprises. Now, as per the guidelines by the Prevention of Sexual Harassment at Workplace, it is the duty of the authorities, it is duty of the employer to ensure safety and to ensure prevent sexual harassment at workplace. They have to create mechanisms for grievance redressal, and women who are getting regular salary, who receive honorarium, even if they are working in a voluntary capacity, or if they are even there as a temporary workers or unorganized sector workers, all of them are covered under this law. If a domestic worker has been harassed, then she has to be, the grievance redressal has to be done by the society's management, housing society's management committee. All workplaces should have an appropriate complaints mechanism with complaints committee, then special counselor, and also other support system, because the victim of sexual harassment always faces variety of mental trauma and psychological trauma. The complaints committee must be headed by a woman. Not less than half of its members should be women. That is also the demand of the law. Complaint committee should include NGOs and any individual familiar with the issue of sexual harassment. Even person with the knowledge of legal system should also be in the committee. Complaints should, redressal of the complaint should be time bound, like in some institution within 10 days of receiving written complaint, then you have to ensure the inquiry, and judgment also has to be time bound. You can't prolong the case for a long period. Confidentiality must be maintained because both the accused and complainant, both of them are working at the same place until the charges or the accusations are proved. We have to consider the accused as innocent, and only when the charges are proved, punishment can be given. Complainants and witnesses should not experience any type of victimization and discrimination during the process of inquiry. That is also the safety given to in these proceedings. In terms of preventive steps, that how to make your campus, how to make your office safe for women to work, there are so many preventive measures which are suggested for the employers. For example, sexual harassment should be affirmatively discussed in the workers' meeting, in the employer-employee meeting. Guidelines should be prominently displayed in the very important strategically placed notice board, so that people are, the message is given that our office or this particular office or enterprise or campus, people are very serious, the authority is very serious about this issue. Employers should assist persons affected in cases of sexual harassment by outsiders. So, if the harassment happens not only by your employees, but even those who deal with your with your office, even those who have a contract in your office, those who provided variety of services to your office and service providers, if they are accused of misbehavior, then also you have to conduct the inquiry and they have to be punished. Another very important preventive step which central and state governments have adopted is the inclusion of like the legislative measures that private employers also observe the guidelines. Names and contact numbers of all members of the inquiry committee should be displayed prominently, whether you are in a housing society or you are in a local self-government body or you are in private or public enterprise or small offices or shops. Employers' responsibility is that they must recognize that sexual harassment is a serious offense, and they have to recognize the responsibility of the company or a factory or a workplace to prevent and deal with sexual harassment at workplace. They had also need to recognize the liability of company in case sexual harassment takes place by the employees or management, anyone who is accused of this crime. Employers are not necessarily insulated from the liability because they are not aware of the sexual harassment by the staff. Like no employer can say that, oh, I did not know that such thing happened. And just because of the ignorance of the employer, that person is not insulated from the punishment that the act provides. In terms of employer's responsibility, like anti-sexual harassment policy must include a clear statement of the employer's commitment to the workplace free of unlawful discrimination and harassment. Clear definition of sexual harassment using examples and visuals is also mandated. Prohibition of such behavior as an offense. So, you can also say that what is construed as sexual harassment must be clearly explained both in words and through images. In terms of the clauses and caveats that you have, Constitution of Complaints Committee to investigate, mediate, counsel and resolve the cases of sexual harassment is very important, and so that the committee members have to be very mature and very knowledgeable and experienced in dealing with such kind of issues. Supreme Court guidelines envisage a proactive role of complaints committee And also prevention of sexual harassment at workplace has a crucial role. That means you have to organize workshops, poster campaign, discussions, seminars, talks by the legal experts, psychologists and counselors about this workplace safety and what kind of behavior, gesture, mannerisms can be construed as sexual harassment. It is thus imperative that committee must consist of persons who are sensitive and also open to the issues faced by women. And in terms of employers' responsibility, we can also say that the statement that anyone found guilty of harassment after investigation will be subjected to disciplinary action. A range of penalties that the complaints committee can levy against the offenders can start from externment or demotion or deduction in your increment or taking away all the responsibilities which give you authority over fellow individual or a co-worker or subordinate. Explicit protection of the confidentiality of the victim of harassment and witnesses is also very important concern for the employers. They have to guarantee that neither the complainant nor the witness will be subjected to any form of retaliation, victimization or vindictive behavior by either employers or the colleagues. It is also advised to the employers that they publish the policy and make the copies available at the workplace. Discuss this policy of safety of women at workplace or sexual harassment free ecosystem with all the new recruits and the existing employees. Third party suppliers and clients, your vendors should also be told that they have that the office or the employers are very, very serious about this issue and no deviation from the good behavior will be allowed. They should conduct periodic training of all employees and with active involvement of the complaints committee. So, complaints committee has to play a proactive role in ensuring inquiry. Now, we need to understand that in last 30 years, there has been more awareness about violence against women. It started with the nationwide anti-rape campaign in 1980 when a young tribal girl was raped by teenage tribal girl called Mathura was raped by two uniformed policemen at dead of the night in the police station, and after that we saw that there has been tremendous discussion on the rape law. There have been several amendments in the rape law and several women's rights organizations emerged throughout the country, and the issue of violence against women, especially the sexual violence against women, became extremely sensitive issue and we saw the same thing culminating in 2013 where we had a big campaign against rape when a young physiotherapist was gang raped in a moving bus and we call it Nirbhaya case. And after that we have a change in the Indian Evidence Act where definition of rape has also been broadened, where even cyber stalking is included in sexual violence. So, the range of issues which are covered by the Act has also reflected on the definition of sexual harassment, because now cyber stalking and stalking like section 354D of Indian Penal Code and section 354C of Indian Penal Code, which talk about the sexual harassment, they have become a crime against the state. So, it is the duty of the state to ensure, and if there is nobody for the victim to, if victim can't fight the case on her own, then it is the state of Indian state that takes the responsibility to protect the women's safety. It also provides for the death penalty for a repeat offenders and also for rape attacks that lead to victim's death, and we have seen series of such cases in a recent past. The law also makes it a crime for police officers to refuse the open cases when they receive complaints from sexual attacks, and now there are guidelines given to all police stations that they have to, when any woman complains of sexual harassment, they have to file the FIR. And if a person is not satisfied with the complaints committee of their own office, then they can also directly approach the police. We also have a very important law passed in 2012 called POCSO, Protection of Children from Sexual Offence Act, which covers the offence of sexual assault, sexual harassment, and also showing pornography to children. And several schools have now become very active throughout major cities in the country, and parent teachers association, principals association, students associations and women's rights organizations have taken up such cases. It is very important for any citizen of our country, any student, youth, women of our country to know some of the very important articles of Indian Penal Code and other laws regarding sexual violence. One very important concern that we have is Section 347, which concerns with wrongful confinement of a person. So, if you are confined, if you are locked, if you are not allowed to go out from your office or your school or any other place where your employer or your colleague or your people in the office, they do wrongful confinement, it is a punishable offence. Section 354 talks about criminal assault of women to outrage women's modesty. In that also now we have a section 354C where voyeurism also is a punishable offence. You can be imprisoned for 1 to 3 years. Section 354D talks about stalking, cyber stalking, where the punishment is maximum for 3 years. Section 366 talks about the it takes care of the kidnap, abduction or marriage of a woman by force. Section 366A punishes a person who procures a minor girl. Section 366B deals with the import of girl from foreign country. Section 376 which deals with the rape, and the rape has been defined in a much broader way where a variety of situations of sexual assault and violence have been taken care of. Section 376A deals with the intercourse by a man with his wife during judicial separation. Section 376B punishes a person, public servant who is involved in sexual harassment or sexual assault of a woman in her custody. Section 376C deals with the superintendent of jail or a remand home or who misbehaves with a woman in his custody, then that person can be brought to book. Section 376D deals with a member of a management or a staff of a hospital with any woman who is there, whether she is a nurse or a doctor or a patient. We have a section 498A. We know that any husband or in-laws who subject women to cruelty, they can also be punished. Section 509 deals with a word, gesture intended to insult modesty of women. So, these are some of the important sections of Indian Penal Code which are also related to sexual harassment. What are the major challenges that we face when it comes to implementation of the law to prevent sexual harassment at workplace? First of all is the custodian of law and order. When they are involved in sexual harassment, it becomes extremely difficult for a woman to fight it out. Abuse of power by the people in authority who are extremely powerful, in that case also we find very difficult, especially like a legal criminal justice system or so many courts, they also do not have appointed grievance redressal committee to deal with sexual harassment. Sunrise sector like information technology is also experiences so many cases of cyber stalking or sexual harassment by the colleagues. Sunrise sector works round the clock. So, women in the sunrise sector like information technology or electronic media or print media, they are working at odd hours. While traveling, so many women have faced sexual harassment. The major challenge that we face is a misogyny, the general hatred, because earlier what we had was a chivalry towards women. Chivalry is also does not treat women as an equal. Woman has to be protected, guided. That is the ideology behind chivalry. But what it is now, what we see is replaced by the hostility towards women, and misogyny is an extreme form of hatred towards women, and you see them as a rival, not as a colleague, and that kind of ideology pervades in workplace ecosystem in today's extremely competitive world, and that has to be challenged through gender sensitization. That has to be changed, because change in the mindset is very important, and that's why we have to begin gender sensitization in a massive way in each and every sector of the economy, and employers have to be very proactive in organizing and the discussion on such sensitive issue, because this is supposed to be the intimate violence, and is very, very important. National Commission for Women, state commissions for women, they have taken lead in discussing this issue, and they have a lot of audiovisual aids, lot of documentary films, and good kind of very hard hitting presentations have been made. There is a very good poster which was made by the women's movement in the 80s, because generally we all resort to victim blaming. Whenever anything goes wrong, we blame the victim, and this victim mentality, the victimhood also creates, it has a very deterring effect in making, say, the victim to come out in open and challenge this kind of violence. It is a very hard-hitting statement that the women's groups have come up with. We always tell our daughters or a women employee or a woman in general that don't go out alone at night. That encourages man. Don't go out alone at any time. Any situation encourages some man. Don't stay at home. Intruders and relatives can both rape. Don't go without clothes. That encourages man. Don't go with clothes. Any cloth encourages man. Avoid childhood. Some rapists are turned on by little girls. Avoid old age. Some rapists prefer aged women. Don't have a father or a grandfather, uncle or brother. These are also relatives that most often rape young women. Don't have neighbors. They often rape. Don't marry. Rape is legal within marriage. To be quite sure, don't exist. Now, this kind of a nihilist attitude will not do. We have to make our women strong. They should not feel any shy of reporting such crime. They should not blame themselves that there is something wrong in their dress code or their body language or their mannerism, or just because they are outperforming, they are too smart that it is happening to them. It is not. It is a widespread disease. We need to collectively fight against it, and women have to muster courage. There should not be any guilt complex they suffer from, and those who are accused, they also they should be punished. And at the same time, we have to come up with a massive awareness campaign that no one is immune to punishment when it comes to sexual harassment at workplace. And that's why in every place, so many panchayat institutions have also taken up this issue. Women who are politically active, they have also faced, and we have seen that even women of a very high stature, very senior leaders, they have also been sexually harassed. And so it is not that it happens to only totally powerless, totally poor woman. It happens to women in any life situation, and that's why we have to combat it. And it is a duty as a citizen that we fight against it. Several organizations and employers organizations, trade unions, students organization, women's organizations, neighborhood committee, citizens forum, all of them have to come out openly. They have to discuss this issue and ensure that freedom from sexual harassment is a condition of work that every employee, every person is entitled to, whether that person is a domestic worker, domestic help in your colony, or a vegetable vendor in the market, or office going woman, or a student in school and colleges. Safe workplace is every person's human right, and we have to ensure that safety. By 1990, we saw that there were many cases which attracted the national level limelight because of the massive protests that happened in our country. when a IAS officer was harassed in front of so many other officers in the official banquet. She took it up to its conclusion. Only after 10 years or so, the judgment was given, but the person who was accused of harassment was an extremely renowned super cop, and nothing, and he was given so many national awards and this thing. So not much happened in that case, but lot of protest had taken place, definitely. But this particular incidents encouraged so many other women working in a high profile jobs, whether they were in Indian Foreign Service or Indian Administrative Service, Indian Economic Service, in the central government jobs. They increasingly started coming out in open and protesting against their harasser. There were two IAS officers in Kerala. They took it up, this issue. They were not, they stood, they were extremely courageous. They were not defied by any threats which were given by the minister who harassed them. They were called on duty and harassed, and they went on a sabbatical, completed their PhD, and they came back, bounced back with a even higher position. And I think when she became an election officer for the state, that minister came to file his nomination as a candidate. So I think some of the cases where these women have taken it up, they have treated this kind of mishap in their life as any occupational hazard, and they have emerged not only not as a victim, they have not been completely ruined, but they have come up and bounced back with more rigor and more courage. There were cases where a chief minister was accused of harassing his secretary. The secretary, it created a big media publicity, lot of protests by women's organizations. But she had to pay the price in terms of break in her marriage. She was engaged, her fiancé broke the engagement, and because in-laws did not want such a celebrity daughter-in-law. That also happened. We have also seen the activist of a women's organization who was given an appointment by environment minister in Uttar Pradesh. That happened in 1991, and he made sexual advances. She took it up. The All India women's organizations also protested against that, and the action was taken. In Air India, air hostesses also formed their own union, and when an air hostess was harassed by her colleague, by a pilot, it became a big issue. And with this particular case, for the first, like, Air India came up with the rules about safety of air hostesses at workplace. Even in the service book of Air India, they said that safety of all women employees in the airlines became a very important concern for the aviation industry. We also have a case of Medha Kotwal case where she took up, and the Union of India, that particular public interest litigation, which created a guidelines for educational institution about safety of students, of women employees, and third party litigation, that if a accused, like if a complainant or a victim of sexual harassment is not ready to come out because of fear of retaliation, then even a third party petition can be respected by the court. So that was a very important concern. In the April Export Promotion Council, again a public sector concern, like where versus A.K. Chopra case in 1999, where a woman PA was called by the top boss in the 5-star hotel in the evening for some meeting, and he molested her, and it became a very important case. It was proceedings took place in the Supreme Court of India, and the accused was punished. Nalco chief was found guilty of sexual harassment, and his services were terminated in 2002 after the massive public protest by the women's organization, massive media coverage, and also court proceedings. There were 3 interns from the National Law School, Kolkata. They also wrote several blogs against Supreme Court judges who were sexually harassing them. And in 2013 and 2014, they approached the National Human Rights Commission with their complaint, and some actions were taken, and all the courts, session courts, high courts and Supreme Courts, all the courts were asked to form grievance redressal cell within the court premises. Owners of Tehelka magazine, he was also brought to book and he is in prison, and the case is still going on. Several women journalists have complained of sexual harassment. In 1997, when an employee of Rajasthan government working in the Women Development Project, Bhavri Devi, she was gang raped, and because she tried to prevent this child marriage. It was her duty to prevent child marriage, and the other things that she had to do as a development worker, community based development worker, was to promote literacy, to make women aware about family planning and small family norm, also give them legal awareness, and prevention of child marriage was also a duty. When she came to know, when the villagers told her that she had to, some child marriage was taking place among Jat community, she went with the police to prevent the child marriage, and the community, the very powerful community, they got enraged that how can such a simple worker, ordinary worker could stop the marriage. They retaliated by raping her in front of all the villagers, and extremely brutal sexual assault took place on Bhavri Devi's body. When she tried to file the FIR, no police station in the village, they refused to file the FIR. After intervention of several women's organizations and NGOs, her FIR was filed. After a lot of media coverage, the case came up in the Rajasthan High Court, and the judgment given by the Rajasthan High Court was extremely misogynist, extremely objectionable, because they said that this educated high caste man, how would they even go near the shadow of a lowly woman, the woman from a potter's community? And that enraged several women's organizations, and on behalf of Bhavri Devi, big NGO called Vishakha filed a public interest litigation in Supreme Court of India. Luckily for them, it was Justice Verma and Counsel Leela Seth. They were involved in this hearing of this case. Justice Verma also invited Women Lawyers Association to come up with the directive, because that was not, at that time we had only section 354 and 509. We did not have a comprehensive law for prevention of sexual harassment. So in his judgment only, he gave a Supreme Court directive, which is known as the Vishakha Directive. In 1997, that Vishakha Directive came into force, where Supreme Court of India recommended to all employers to come up with laws, their own guidelines regarding safety of women at workplace. I would like to conclude with a statement that no woman should keep quiet, or no person should keep quiet when they face sexual harassment at workplace or any life situation. The sense of guilt or shame should not be attached to it. It is the accused, it is the person, predator, who should have the burden of guilt, not the victim. That is one very important lesson that we all have learned from the experiences of women and men who have gone through this sexual harassment at workplace. The second one, that now we have a legal system which responds to this kind of tragedies, and they also ensure that the justice will be dispensed, and timely justice will be dispensed. There are several states which have also come up with the fast track court to give a very quick, because justice delayed is justice denied. So that principle is also accepted by us, and overall sensitivity towards this kind of harassment, that it is a violation of bodily integrity, dignity, and the sanctity of an individual, and sexual harassment is not just a matter of joke, it is a very, very serious offense, whether it is in the form of lewd statements or a song or a body gesture. This kind of violation should not be tolerated by anybody, and we have a law which is supportive to the victim.